Hi and welcome. Today I'm going to talk about the struggle for control of American media in the case of Missouri versus Biden. Missouri versus Biden, the case that's seeking to limit the Biden administration's contacts with social media platforms, is really a dispute about content moderation on social media. It's also about whether right-wing conspiracy theories about COVID, vaccines, and the election should be allowed to spread unchecked and unchallenged. The case also embraces the libertarian and anarchist view of government. I'll explain. So the case, in a nutshell, the plaintiffs include the states of Missouri and Louisiana, their attorney general, and a few others, including a Stanford professor of medicine who opposed vaccine requirements and lockdowns. The plaintiffs filed a lawsuit accusing Biden and his administration officials of operating what they called an open and explicit censorship program. They claimed that Biden and his administration, quote, threatened and cajoled social media platforms to censor viewpoints and speakers disfavored by the left. And they accuse the administration of now entering a phase of open collusion with social media companies to suppress disfavored speakers, viewpoints, and contents. The plaintiffs assert that the Biden administration is operating this censorship operation under what they call the Orwellian guise of halting so-called disinformation, misinformation, and malinformation. The applicable law in a nutshell. The First Amendment applies only to actions by the government and not to the actions of private persons. Under the First Amendment, the government is permitted to advise or try to persuade media outlets, but the government is not permitted to engage in what is called jawboning, which is defined as behavior that is extremely coercive. Basically, the government can try to persuade, but it cannot intimidate. The complaint basically argues that, number one, government officials spoke and offered strong opinions, and social media platforms censored the right-wing viewpoints, and therefore, the plaintiffs conclude that the government officials forced the social media platform into censoring what they call political speech. Now, plaintiffs offered the following as examples of right-wing speech that they claim was, quote, censored. The Hunter Biden laptop story, speech questioning the efficacy of masks and lockdowns as mitigation measures, and speech about election integrity and the security of voting by mail. These stories were not given a lot of airtime by mainstream media, and influencers on social media paid no attention to them. Why? Because people thought they were bogus. But the plaintiffs believe that the reason that these things were not given more exposure is because the government was suppressing this kind of speech. So plaintiffs offer these examples of what they call censorship. Both Twitter and Facebook took extraordinary censorship measures against the Post over its exposés about Hunter Biden's emails by locking the Post's primary Twitter account. Then they offer this other example. The Wall Street Journal editorial board reported that nearly all the media at the time ignored the Hunter Biden laptop story, or they fact-checked it as false. Another example. During the major COVID-19 outbreaks, Twitter, quote, censored, labeled, or removed speech claiming that face masks do not work to reduce transmission or protect against COVID. Another example. On April 8th, 2021, YouTube deleted a video in which Florida Governor Ron DeSantis and a handful of, quote, medical experts, including some of the plaintiffs, questioned the effectiveness of having children wear masks to stop the spread of COVID-19. So, plaintiffs offer these examples of what social media did to claim that the government forced them to do this and that the government was censoring. So here's examples given by the plaintiffs. On May 5th, 2021, defendant Psaki gave a White House press conference at which she stated that, quote, the president's view is that the major platforms have a responsibility related to the health and safety of all Americans to stop amplifying content, disinformation, and misinformation, especially related to COVID-19 vaccinations. Another example of what the plaintiffs consider White House censorship. At a White House press conference briefing with Psaki On July 15, 2021, Surgeon General Murthy announced that health misinformation constitutes an urgent public health threat. He said he had issued a Surgeon General's advisory on the dangers of health misinformation. He also said that such advisories are, quote, reserved for urgent public health threats, and added that while those threats have often related to what we eat, drink, and smoke, today we live in a world where misinformation poses an imminent and insidious threat to our nation's health. Another example, offered by the plaintiffs, then Senator Kamala Harris on September 30th, 2019 said, look, let's be honest, Donald Trump's Twitter account should be suspended. Plaintiffs allege that the government also threatened to revise Section 230 of the Communications Decency Act of 1996 in a manner that would deprive social media platforms of some of their freedom. Evidence of such threats listed in the complaint include Speaker Nancy Pelosi on April 12, 2019, saying, I do think that for the privilege of Section 230, there has to be a bigger sense of responsibility on it. And it's not out of the question that it should be removed. Now, this is not a threat. Government officials, particularly members of Congress, are always talking about revising legislation. As another example of the threats or coercion that the plaintiffs cite, they give a letter that the members of Congress sent to Facebook. According to the complaint, the members of Congress demanded that Facebook address Spanish language disinformation across the platforms. Well, I went to look at the letter, and here it is. The letter opens with, we write to you regarding our serious concerns with Facebook's lack of progress addressing the pressing issues of Spanish language disinformation across its platforms. The letter informs Facebook that efforts to target Spanish-speaking communities originated in Russian-controlled outlets. The letter then admonishes Facebook for continuously failing to show that it is adequately addressing this problem for Spanish-speaking communities, and pointed out that Russian-sponsored disinformation outlets were succeeding in targeting American Spanish-speaking communities. Congress concluded with a request that Facebook answer questions about the steps they plan to take. Now, from those government actions, the plaintiffs conclude that the reason why Facebook and Twitter and other outlets started telling people, no, don't listen to this bad information, is because the government was forcing them to do that. The remedy they seek, they're asking for the court to find that the government's behavior, as outlined here, was unlawful, and they want the government order to stop. Now, such an order would effectively forbid the government from talking to social media platforms at all, or from talking about any kind of content on social media. The government responded to these accusations by explaining that an important part of the executive function is to speak to members of the American public, including American companies, about how they can help mitigate threats to the nation. The government said this, from President Kennedy's extortion for steel companies to lower their prices to President Trump's efforts to encourage companies to keep American jobs onshore, presidents and other officials have long exercised the power of persuasion to advance their vision of the public good. For example, the FBI routinely shares with platforms intelligence regarding accounts that appear to be used by foreign malign actors to influence American politics, or by foreign terrorist organizations to recruit supporters. And the government's argument, basically, from what we can see from the filings, is this. Such an order would impede the executive branch from carrying out its functions and would violate the separation of powers by allowing the judiciary to regulate executive branch speech. Moreover, they say, the plaintiffs have no standing to bring this action, so the entire case should be thrown out. So what is this case about? Well, the lawsuit is giving voice to a long-held right-wing belief that mainstream media, the federal government, and powerful high-tech companies are all in collusion to censor and ban their political views. The lawsuit rests on the right-wing view that the federal government routinely engages in nefarious efforts to infringe on the liberty of individuals. In this case, the liberty being infringed is what plaintiff believes is their right to have their political views given prominence in the media. The case matters because many, if not all, of the difficulties we're now having holding on to democracy come from the way people get their information. The logical error in this brief is that the plaintiffs confuse chronology with causation. Government officials said X. Facebook did Y. Therefore, Facebook did Y because government officials said X. What they want is for the government to shut up and back out of it. Now, if the government does nothing and platforms continue to muzzle certain speech, they know they can't do anything about it. Private platforms can do what they please. This is the, quote, the government should stay out of everything argument put forward by people who think individuals should be allowed to do any of the following without government interference. Carry semi-automatic weapons, dump pollutants into rivers, refuse to pay taxes, cheat customers. This is the caveat emptor theory. Now, here's the procedural history so far in this case. The plaintiffs filed their complaint, which is the document initiating the lawsuit. They asked for a preliminary injunction preventing the Biden administration from talking to social media companies as the lawsuit proceeds. Now, a preliminary injunction is something that's necessary to prevent irreparable harm as the lawsuit continues. They allege that the government should be muzzled even before they get a ruling on their lawsuit. Now, the government then appealed the preliminary injunction, and the Court of Appeals sided with the government on this, so there is no injunction. So I want to point out the parallels between the worldview articulated in this case, Missouri versus Biden, and Elon Musk's vision for Twitter. When Musk purchased Twitter, he claimed to be a free speech absolutist, and he promptly reinstated accounts that had been banned for spewing racist, dangerous lies. To take two examples of many, Musk reinstated Andrew Tate and Lin Wood. Wood was suspended after January 6, 2021, when he tweeted that former Vice President Mike Pence should face, quote, execution by firing squad. Musk also told Trump that he'd be welcome back. In December, shortly after buying the platform, in an attempt to give credit to right-wing talking points that Twitter intentionally silenced conservatives because of their political views, Musk and a few of his allies began releasing a series of internal documents. They released these documents to a hand-picked group of journalists who posted excerpts on Twitter. These documents compose what have been called the Twitter files. Now, the so-called Twitter files did not prove that right-wing views were unfairly censored, but they succeeded in fueling the right-wing talking points echoed in Missouri versus Biden. In fact, internal researchers at Twitter found that even before Musk's purchase of Twitter, right-wing views tended to be favored by the internal algorithms. Soon after purchasing Twitter, Musk began to, quote, empower right-wing viewpoints. Within a few months, he turned the site into a far right-wing social network. He removed fact-checking and content moderation, which is exactly what the plaintiffs wanted to happen in Missouri versus Biden. Musk is now paying Andrew Tate and other right-wing extremists for their contributions to Twitter. And he's also finding ways to amplify their messages. The pattern is the same in Missouri versus Biden. The plaintiffs began by asserting that their views were being censored, then insisted that their views be given dominance and allowed to spread unchecked and unquestioned. You see, right-wingers don't merely want their own platforms. If they did, they would all congregate on Truth Social or Parler. What they want is to dominate all platforms. This is why the plaintiffs in Biden versus Missouri want to remove any possibility of legitimate criticism from official sources. Thank you. I hope you found this helpful.